There are 16 children inside that house. The youngest is 18 months old. The oldest is 18 years old and cannot write her own name. They are in a room the size of a parking space. And nobody, not a single person outside those walls, had any idea they existed. That is not a headline. That is what sheriff's deputies in Vinton County, Ohio, walked into on an ordinary summer afternoon when they showed up to serve a warrant that had nothing to do with children at all. What happened next, what investigators found, what the evidence suggests had been building for years inside a house on Omar Street in a village most people have never heard of, is one of the most disturbing child welfare cases in recent American history. And right now, the legal proceedings surrounding it are unraveling in ways that are raising serious questions about whether anyone will ever fully answer for what happened to those kids. If you want to understand what is actually happening in this case, stay with me, because there is a lot to get through, and almost none of it has been covered with the detail it deserves. And if this is the kind of story you believe deserves attention, take a second right now to subscribe to Crimes Records. This channel exists precisely for cases like this one. The village of Hamden sits in Vinton County, Ohio, in the foothills of the Appalachian Plateau. It has a population of fewer than 900 people. Vinton County itself is the least populous county in the entire state of Ohio, a rural stretch of hills and small communities where resources are thin, infrastructure is limited, and the county grand jury convenes only once every 2 months because there simply isn't enough caseload to justify meeting more frequently than that. It is, by most measures, a place where not very much happens, and for years, that quiet was part of the problem. On the morning of June 30th, deputies from the Vinton County Sheriff's Office drove to a residential address on Omar Street in Hamden to serve a warrant. The warrant was routine. It was unrelated to child welfare, unrelated to any complaint about the family living there, unrelated to anything that would have prepared the officers for what they found when they stepped through that door. What they encountered was not the result of a tip. It was not the outcome of a months-long investigation. It was not the product of a neighbor calling 911, or a teacher reporting an absence, or a doctor flagging something unusual. It was a discovery in the most literal sense of the word, the uncovering of something that had been sitting there hidden for a very long time. Inside the home, deputies found 16 children. Their ages ranged from 18 months to 18 years old. They were found confined, largely, to a single room. That room measured approximately 12 feet by 12 feet, 144 square feet, smaller than a standard prison cell designed to hold a single adult inmate. Pace that out wherever you are right now. 12 steps in one direction, 12 steps back. That is the entire space. That is 144 square feet divided 16 ways, which gives each child roughly 9 square feet of space. 9 square feet is smaller than the footprint of a twin mattress. That is before anyone moves. That is before anyone tries to sleep. That is before 16 human beings attempt to simply exist in a space that was never designed to hold more than 1 or 2 people in any reasonable capacity. Human waste was found throughout the home. Several of the children were reportedly unable to speak. One child, 18 years old, legally an adult by every measure, could not write her own name. 7 of those 16 children required hospitalization. 2 of them were so severely injured they had to be airlifted by medical helicopter to trauma centers in Columbus. 1 child was listed in critical condition upon arrival. Ohio Attorney General Andy Wilson said publicly that the children appeared almost like feral animals. The Vinton County Sheriff said his own livestock was kept in better conditions than the children found inside that house. The Attorney General also stated that no cages were discovered in the home, which sounds like a clarification until you realize what it reveals about how low the bar had already dropped. The absence of cages had become the good news. None of it was discovered because someone asked for help. No one called 911. No one reported these children as missing or in danger. No welfare check had been requested. These children were found the way you find something that has been there all along, untouched and unseen, waiting for someone to finally open the right door. As far as the immediate neighborhood was concerned, those 16 children did not exist. A neighbor interviewed afterward by the Associated Press said he had never once seen a single child at the property. Never. Not in passing. Not in the yard. Not at a window. Another neighbor said she had caught a glimpse of some of the children on one occasion at a yard sale and noticed they appeared dirty. She assumed they had been playing outside. She said she is losing sleep over that assumption now. These were not invisible children in a metaphorical sense. They were literally unknown to the world around them. No school records, no medical appointments, no birthday parties, no Halloween costumes glimpsed from across the street, no noise from a yard full of kids on a summer afternoon. 16 children, spanning nearly 2 decades of births, had been maintained in a state of near total concealment from everyone outside those walls. 4 adults were arrested in connection with what was found inside that house: the mother, the father, and the paternal grandparents. Each of the 4 faces 16 counts of child endangering, a second-degree felony in the state of Ohio that carries between 2 and 12 years per count. All 4 have entered pleas of not guilty. That is where this case began. What has happened since then is where it gets significantly more complicated. The grandfather, Gary Sider Sr., 73 years old, was being transported to what was scheduled to be a preliminary court hearing when he collapsed. He was taken by emergency services to Ohio Health Obelness Hospital in Athens, Ohio. Doctors there ran evaluations and determined he has a serious medical condition, one serious enough to require specialized care at a larger facility outside the region. Nobody has said publicly what that condition is. His attorney declined to identify the hospital he was subsequently transferred to, citing medical privacy. What followed from that hospitalization set off a chain of legal decisions that drew immediate and understandable public reaction. Because Gary Sider Sr. has not been convicted of any crime, the cost of his medical care falls on the county, not the state. That is how pretrial detention works in Ohio. And Vinton County, the least populous county in the state, a jurisdiction small enough that its grand jury meets every other month, determined it could not absorb that financial burden. Prosecutor William Archer addressed the situation plainly. The community is not at risk because of this bond decision. This is not about trust. It is about mathematics. His medical care had the potential to bankrupt the county, and local taxpayers were not going to be the ones covering it. So the judge converted his $300,000 cash bond into a $300,000 recognizance bond, which in practice means the court is trusting that he will return when required. If and when he is released from the hospital, he will be fitted with a GPS monitoring device. The timing of all of this is difficult to sit with and would be dishonest to dismiss. A man facing 16 felony counts, a man facing a potential combined sentence measured in decades, collapsed on his way to a hearing and was effectively released from custody. It looks the way it looks, but when you work through the actual legal logic, the math is what it is. He has not been convicted. The county pays for his care while he awaits trial. The county cannot pay. That is the mechanism at work, regardless of how uncomfortable the outcome feels. What came next made the picture considerably more complicated. Just days after the hospitalization, Gary Sider Sr.'s attorney, Dorian Baum, filed a motion requesting a full competency evaluation. Alongside it came a formal notice that the defense is considering pursuing a not guilty by reason of insanity plea. These are 2 distinct legal questions, and the distinction matters enormously because they are routinely confused, and that confusion shapes how the public understands what is actually at stake. Competency is a question about right now. Can this defendant, at this moment, understand the charges that have been brought against him? Does he understand who the people in the courtroom are and what roles they serve? Can he meaningfully assist his own attorney in mounting a defense on his behalf? If the answer to those questions is no, the case does not move forward. It freezes entirely. The defendant would be sent for formal evaluation and, if appropriate, restoration treatment at a mental health facility, where the goal would be to bring him to a sufficient level of understanding that proceedings could resume. If he can be restored to competency, the case picks back up. If evaluators determine that no available treatment can bring him to that baseline level of understanding, he is deemed permanently incompetent. The charges do not disappear. They simply exist in a state that cannot be resolved through a traditional criminal trial. The defendant may never face a jury. The case may never reach a verdict. Insanity is an entirely separate question, and it only becomes relevant once the competency issue is settled. It does not ask about right now. It asks about then, about the specific moments when the alleged offenses occurred. It asks whether, at those moments, the defendant understood that what was happening was wrong. This is a narrow legal standard, not a casual cultural shorthand for erratic behavior. It is not something that gets deployed to sidestep consequences on a technicality, despite everything said about it in comment sections. A person can meet the legal threshold for not guilty by reason of insanity because they were experiencing severe command hallucinations. A person can also meet it because an advanced deterioration of mental function, dementia, for instance, had reached a point where they genuinely could not appreciate the wrongfulness of what was taking place around them. It is a high bar, narrowly applied, and it results in commitment to a psychiatric facility rather than freedom. Gary Sider Sr.'s attorney described what he personally observed during his meetings with his client. Significant confusion about the legal process. An inability to identify the roles of the people involved in his case, including, notably, his own attorney's role. An inability to maintain a coherent or consistent train of thought from one moment to the next. He described a man who could respond to a basic greeting, but could not engage with any sophistication about what was legally happening to him or what it meant. The attorney noted that collateral information appeared to support his client's genuine mental decline, while being careful to clarify that he is not a medical professional and is not offering a diagnosis. He also described real physical deterioration alongside the cognitive concerns, significant mobility problems, difficulty hearing what appear to be serious hip issues, and an expectation that his client may require a wheelchair on a full-time basis, not simply for the one court appearance that ended with his collapse. He described his client as, in his own words, a sad and sympathetic character, and made clear he was not using that description in reference to the charges, but in reference to the sheer level of confusion and physical decline he observed in every interaction. When asked whether he expected the prosecution to oppose the competency motion, the attorney did not express concern. In his experience, good faith competency evaluations are not typically contested because they are not a defense strategy. They are a constitutional requirement. You cannot move a criminal case forward against a defendant who does not understand what is happening to him, regardless of how strong the evidence against him may be. The prosecutor himself appeared to acknowledge that much publicly without raising any objection. A judge has since ordered both the competency evaluation and the mental health evaluation to proceed. The results of those evaluations, and what they will mean for whether a 73-year-old man ever stands trial for what was found in that house, remain pending. The other three defendants, it should be noted, have not raised similar questions about their own fitness to stand trial. Before this case can be fully understood through a legal lens, it has to be understood through a human one. And that requires going back further than June 30th. It requires understanding who this family was, how it came to occupy that house on Omar Street, and what the people who knew them say about how they got from wherever they started to the place investigators found them. A family member named Ronnie Fletcher, married to one of Gary Sider Sr. and Christina Sider's other daughters, a daughter not involved in the current charges, pushed back publicly on the narrative that the Sider family was always defined by what law enforcement found. He described the grandparents as having raised 4 other daughters who are, in his words, successful members of society. He described the home where they once lived as clean, functional, and ordinary. He used the phrase, a normal American home. He described Elizabeth, the mother of the 16 children, as someone who came from a difficult home life as a teenager and was drawn to the Sider household, not forced there, but drawn to it because it represented something more stable than what she had known. Photographs from 2023 appear to support at least part of what Fletcher described. The grandparents in those images look well, composed, and unremarkable, nothing that would suggest to an outside observer that anything was wrong. This detail is not offered as exculpatory. It is offered because it raises the question that sits at the center of everything and that no one has yet fully answered. If this family was once functional, if this home was once ordinary, what happened? When did it happen? And why did none of the systems that exist to catch exactly this kind of deterioration catch it? Investigators have reported that the family moved through multiple Ohio counties over the years, and at some point relocated to Wisconsin before eventually settling in Vinton County. There are also reports that Children's Services in a county near Vinton once conducted a welfare visit to the family. According to those reports, the family relocated shortly after that visit. Some investigators and officials believe that relocation was deliberate, a calculated effort to stay ahead of the kind of institutional oversight that might have resulted in the children's removal. The Ohio Attorney General said it directly. The family was good at hiding these kids. If that is accurate, then what unfolded inside that house did not begin on Omar Street. It built across years and across counties, sustained in part by a consistent pattern of movement that kept it just far enough ahead of anyone who might have intervened. Elizabeth Sider is 33 years old. Her attorney, Tommy Staley, has filed a motion asking the court to reduce her $300,000 bond, arguing that she has no known prior criminal history, no prior failure to appear in court, and that she has cooperated fully with the investigation since her arrest. If released, her attorney says she would wear a GPS monitor, check in with a bond officer as frequently as the court specifies, and maintain a stable address within Vinton County or a neighboring county. He also argues that the risk the original bond amount was designed to guard against no longer exists in the same form, because the children who would have been at risk have already been removed from the home by the state. And he notes, without elaborating, that Elizabeth does not have the financial means to post any amount of cash bail, connecting that directly back to the extreme poverty that prosecutors say characterized the household. According to her attorney, Elizabeth's primary concern since her arrest has been the possibility of eventually reuniting with her children. He noted in his filing that she understands reunification of any kind becomes impossible if she fails to appear in court, and he framed that understanding as itself the most compelling argument that she would not flee. She has nowhere meaningful to go, and she has nothing to gain by disappearing. Prosecutors had not formally responded to that bond motion as of the most recent reporting, so whether the state will oppose her release remains an open question. But the motion, and everything it presents about Elizabeth as a cooperative, non-threatening defendant without resources or record, leaves out the context that matters most when trying to understand who she is and what her role in all of this actually was. Elizabeth was 15 years old in 2008 when she married Gary Sider Jr. in the state of West Virginia. He was 18. Her parents consented. A judge gave consent. Court records show that at the time of the marriage, Gary Jr. had completed the 9th grade. Elizabeth had completed the 8th. There is no indication that either of them pursued further education after the wedding. Their first child arrived 2 months after the marriage, which means Elizabeth was already pregnant at 15 when she stood in front of that judge. More children followed, arriving at a pace of roughly 1 per year for most of the next 18 years, including 2 sets of twins among the 16 who survived. But 16 is not the full number of children Elizabeth carried. In November of 2022, Elizabeth gave birth to another set of twins. Girls. They were named Bailey Lee Sider and Faith Lee Sider. They were conjoined. They were born extremely premature, at an estimated 24 weeks gestation, at Riverside Methodist Hospital. Both girls died the same day they were born. State records confirm this. Officials have said this loss is not currently connected to the endangering charges filed against the family, but investigators have acknowledged it adds another layer to the family's history they continue to examine. Including Bailey and Faith, Elizabeth is believed to have given birth 18 times since she was a teenager. From age 15 to age 33, she was pregnant or raising a newborn for the overwhelming majority of those years. There is no public record of her ever having worked outside the home, attended any form of schooling beyond the 8th grade, or lived independently of the Sider family at any point after that marriage in 2008. Her attorney was asked directly and without ambiguity whether he considers Elizabeth a victim in all of this. He did not give a clean answer. His office, he said, is not sure. He noted that she has not demonstrated the behavioral patterns typically associated with victim status, while also acknowledging that the investigation is still ongoing and that the picture is not yet complete. It is a remarkably candid thing for a defense attorney to say in public about his own client, and it tells you something important. Even the person whose job it is to present Elizabeth Sider in the best possible light has not settled on how to frame what she was inside that house. One of Elizabeth's brothers posted publicly during this period, attempting in some ways to offer context and in other ways to minimize the severity of what law enforcement described. He leaned heavily on the idea that limited intelligence, rather than deliberate cruelty, was behind what happened to the children. He disputed some of the more disturbing details reported by investigators. He argued that the family did the best it could within its limitations, and he placed the primary responsibility on the man he described as the leader of the household, suggesting the others simply followed without fully understanding the consequences of what they were participating in. That statement drew significant criticism online, and it does not shift the legal weight against any of the defendants. But in a case receiving this level of public attention, commentary of that kind shapes the narrative around it whether it is intended to or not, and it reflects the complicated family dynamics that investigators are still working to fully document and understand. If you have been following this case, and you want to stay updated as it develops, now is a good time to subscribe to Crimes Records and turn on notifications. Every update in this case will be covered here, and there is still a great deal left to unfold. To understand what the children found on Omar Street may have experienced, it helps to look at the closest comparable case in recent American history, because a retired detective who lived through that case has been watching what is happening in Ohio, and the parallels he is drawing should not be taken lightly. In January of 2018, deputies with the Riverside County Sheriff's Office in California responded to a home in the city of Paris after a 13-year-old girl managed to escape through a window and call for help. Inside the house, they found 12 of her siblings, ranging in age from 2 to 29 years old, some of them so malnourished that they appeared to be children even when they were legally adults. A 17-year-old weighed 82 pounds. They were shackled. They were starved. They had been confined for years inside a home their parents controlled absolutely. Their parents, David and Louise Turpin, were arrested that same day. They were ultimately convicted of torture, false imprisonment, and a range of additional charges. Both are now serving life sentences. Both will die in prison. The detective who led the original rescue operation for the Turpin case is Thomas Salisbury, now retired. He has weighed in publicly on what is happening in Vinton County, Ohio, and what he sees concerns him deeply. The parallels he identifies are not superficial. In both cases, children span a wide range of ages. In both cases, there are no school records, no medical records, no documentation of any engagement with the outside world in any normal sense. In both cases, the children were confined, physically deteriorating, and discovered not because anyone asked for help, but because of circumstances the family could not fully control. Salisbury described his reaction to the Ohio case as an immediate flood of memories. He described walking into the station after the Turpin children were rescued and seeing some of them standing in a courtyard with their arms raised toward the sun, as though the experience of being outside and feeling warmth on their skin was something they had almost never been allowed. Their clothing was caked with filth. Their bodies were so emaciated that he said they resembled, in his own words, internment camp photographs from the Second World War. But Salisbury has also identified one difference between the two cases that he believes may make the Ohio situation harder in certain ways than what he encountered in California. In the Turpin household, despite everything, the older siblings had built something among themselves. They had developed an internal support network. The older children passed informal lessons down to the younger ones. They taught basic reading, shared coping strategies, created something resembling a mutual protection system within the walls of the house that imprisoned them. It was not sufficient. It was not anything close to what those children deserved, but it existed, and it meant that most of the Turpin children, when they were finally rescued, could speak, could read at some functional level, and could, with significant professional help, eventually build something resembling a life. In Ohio, investigators say several of the children cannot speak at all. The oldest child in the home, the 18-year-old, cannot write her own name. If those details are accurate, and officials have stated them publicly and on the record, they point toward a depth of developmental deprivation that may exceed what Salisbury encountered with the Turpin family, where the older siblings had at least managed to construct something self-directed among themselves. In Ohio, there is no evidence of any such internal system. Whatever was happening inside that room on Omar Street left no room for the kind of informal learning and mutual support that gave the Turpin children a fragile but real foundation to build their recovery on. Salisbury used the word heartbreaking. The Ohio Attorney General used the word feral. Two men, from different states, with different professional backgrounds, looking at the same documented reality from different angles, arriving at descriptions that point toward exactly the same thing. On the question of what charges these 4 defendants ultimately face, legal observers and professionals who have worked comparable cases have noted that the current charges may not represent the end of the prosecution's legal strategy. They may represent only its beginning. Each of the 4 defendants currently faces 16 counts of child endangering, which is a second-degree felony in Ohio carrying between 2 and 12 years per count. Child endangering, as a legal standard, does not require prosecutors to establish that a defendant specifically intended to harm a child. It requires demonstrating that a caregiver's actions, or deliberate inactions, created a substantial risk to the health or safety of a child in their care. That is an important distinction because it is a lower evidentiary bar, and it is one prosecutors can establish relatively quickly with the evidence available in the earliest stages of an investigation. Torture and false imprisonment, the charges that resulted in life sentences for David and Louise Turpin, require something more. They require prosecutors to establish a sustained, deliberate pattern of confinement or cruelty, and that kind of evidentiary case typically depends on detailed medical documentation compiled across multiple cases over weeks or sometimes months of careful analysis. 16 children seen by medical professionals at multiple hospitals and trauma centers, generating medical records that take time to compile and interpret across that many individual cases. The full evidentiary picture is not assembled overnight. The initial charges filed against the 4 Sider family members likely reflect what investigators could establish with confidence in the first days after the discovery. They are not necessarily the final word. Investigators and the Ohio Attorney General's office have stated explicitly and on the record that additional charges remain a possibility. Salisbury himself has said that based solely on the documented medical condition of the most seriously injured children, he believes there may be grounds for kidnapping for torture charges, even without the physical shackles and restraints that were present in the Turpin case. Fear, sustained confinement, and deliberate deprivation can meet the legal threshold for those more serious charges without requiring chains. The question is what the full medical evidence, once compiled, actually shows. There is also a practical dimension to the resource challenge facing the prosecution. Vinton County is not equipped to handle a case of this magnitude on its own. 2 special prosecutors have been brought in to assist the local office. One is an assistant attorney general with extensive experience in child welfare cases. The other is a prosecutor from neighboring Highland County, who William Archer, the local prosecutor, describes as a former colleague and a trusted resource. Both are being provided to Vinton County at no cost to local taxpayers through the Ohio Attorney General's Special Prosecution Section. The Attorney General's office noted that nearly half of Ohio's 88 counties have requested similar support over the past year, framing the assistance not as an unusual intervention, but as a practical response to a case that has grown beyond what a small rural office can realistically manage alone. All 4 defendants have waived their rights to preliminary hearings. That decision means the public will not receive an early, detailed accounting of the state's evidence. The evidence will remain sealed and unaired until the case reaches indictment or trial, whichever comes first. Given that the Vinton County Grand Jury meets only every other month, that timeline is not moving quickly. There are also significant investigative questions that remain publicly unanswered. Whether Gary Jr. and Elizabeth were ever receiving government welfare benefits, and if so, what records those benefit applications generated about the size of the household and the ages of the children in it. How many times over the years this family crossed paths with children's services in various counties without anyone catching what was actually happening inside the home. And whether Gary Sider Sr. will ever be found competent to stand trial at all, or whether he will remain in a legal limbo from which the case against him can never be resolved through conventional judicial process. Each of those questions matters independently. Together they form the outline of a system that appears to have missed this family repeatedly across multiple jurisdictions over multiple years. That is not a small observation. It is perhaps the most important structural question this case raises beyond the immediate legal proceedings, because whatever failures allowed this to continue for as long as it did are failures that could allow something similar to happen somewhere else, unless they are identified and addressed honestly. Now take a moment, if this case matters to you, to like this video. It helps crimes records continue covering cases like this one in the depth they deserve, and subscribing ensures you will be here when the next update breaks. But the courtroom proceedings, the charges, the competency hearings, the bond motions, the grand jury timeline, none of it is the most important part of what this case is ultimately about. The most important part is 16 children. And right now, what is happening to them matters more than anything taking place in a Vinton County courtroom. Officials have confirmed that all 16 children are in state custody and have been placed in what authorities describe as safe environments, with multidisciplinary teams coordinating their medical care and behavioral health services. Safe is a word that carries real weight only if someone is watching closely enough and consistently enough to make sure it stays true over time. Rescue is not the same thing as recovery. That distinction sounds simple, but it is easy to forget when the immediate crisis has passed and attention has moved on. Thomas Salisbury has been specific and direct in his advice about what needs to happen for these children. Keep them together in one place, he has said. Do not scatter them individually across the foster care system, where individual oversight can quietly erode without anyone noticing until it is too late. Bring the professionals to the children. Do not make the children navigate a fragmented system while they are still in the earliest and most fragile stages of whatever recovery is possible for them. This advice is not abstract or theoretical. It is built on direct experience of watching things go wrong after a rescue that was considered a success, on seeing children he had helped pull from one nightmare land through institutional gaps in another one. The Turpin children are, according to Salisbury, largely thriving today. Years after what was done to them in that house in Paris, California, most of them have found pathways towards something that resembles a life. That recovery took time. It required specialized professionals with genuine expertise in extreme developmental trauma. It required sustained, relentless oversight of every placement and every service provider. It was not automatic, and it was not fast, but it happened. The question of whether the same can be said for the 16 children found on Omar Street in Hamden, Ohio, is not yet answerable. It depends on decisions being made right now by people whose names have not appeared in any news coverage of this case. It depends on whether the state of Ohio commits the resources necessary for long-term, specialized, coordinated care, and then follows through on that commitment after the cameras have moved on. It depends on whether anyone is watching. There is one figure in this case who has received less public attention than she deserves, and whose situation may be the most urgent and the least addressed of anything connected to what happened in that house. The 18-year-old. She is legally an adult. She was found in that room. She cannot write her own name. By every functional measure available to investigators, she has spent the overwhelming majority of her remembered life confined inside a house that operated, by every official description, closer to a holding cell than a home. She is now 18, which means she is already at or near the threshold at which many of the protective systems designed to support children begin to fall away. Foster care, state custody arrangements, the services that exist specifically for minors who have been removed from dangerous situations. What happens to her when she ages out of whatever protective framework is currently in place? What services exist for an adult with profound developmental delays caused by years of deliberate deprivation? What does a path forward look like for a young woman who has never attended school, cannot write her own name, and has spent her entire childhood in a 12 by 12 room? Nobody has addressed that publicly. Nobody, as of the most recent reporting, has offered any answer to those questions on the record. It may be the single most urgent question in this entire case that has nothing to do with what happens in a courtroom. Because whatever verdict eventually comes down in Vinton County, whatever sentence is or is not imposed on whoever is or is not found competent to stand trial, that verdict does not determine what kind of life she gets. That is determined by the decisions being made about her care right now, and by whether the people making those decisions are asking the right questions with enough seriousness to actually answer them. The same is true in varying degrees for each of the 15 other children pulled from that room. From the toddler at the youngest end of that age range, whose earliest memories of the world are whatever was inside those walls, to the children in the middle, who may have the longest recovery ahead of them. Every one of those 16 lives will be shaped more by what comes after the rescue than by the rescue itself. That is the lesson of the Turpin case, stated plainly. The victory was getting those children out. The work was everything that came after. This case is not over. It has barely begun. The grand jury has not yet convened. The competency evaluations have not returned results. Additional charges have not been filed, but have not been ruled out. The bond motions are unresolved. The full scope of what happened inside that house across all 16 children is still being compiled from medical records at multiple hospitals. The question of how this family evaded detection across multiple counties and years has not been answered. The question of what failed and where and who is accountable for those failures at the systemic level has not been asked loudly enough. What is clear right now is this. On June 30th, in a small village in the least populous county in Ohio, 16 children were found in conditions that officials with decades of law enforcement experience described as worse than what they had seen for animals. The family surrounding them has been charged but not yet tried. The legal process ahead is long, complicated, and in at least one defendant's case, may never reach a conventional resolution. And 16 children, whose existence was unknown to nearly everyone outside that house, are now in the custody of a state that has a history of getting this kind of thing both right and profoundly wrong. The details of this case are not finished emerging. The investigators are still working. The prosecutors are still building. The courts are still moving. And somewhere in Ohio, 16 children are beginning the long, uncertain process of learning what the world outside that room actually is. This story will continue to develop, and Crimes Records will be here to cover every update as it comes. If you want to make sure you do not miss what comes next in this case, or any case like it, subscribe to the channel now and hit the notification bell. And if this video gave you something you did not have before, leave a like. It is the simplest way to make sure coverage like this keeps reaching the people who need to see it. Because these children existed before anyone knew their names. They exist now. And whatever happens next, they deserve to have someone paying attention.